Hello everyone. My name is Stephen, and welcome to Randy I Law Office, your trusted source for employment law. Today, we will be discussing a topic that affects many employees in Ontario, and that is constructive dismissal. Constructive dismissal occurs when an employer makes significant changes to the terms and conditions of an employee's employment without the employee's consent, making it impossible for the employee to continue working in their current role. It is important to understand that a constructive dismissal is not the same as a regular termination of employment, as the employee is not explicitly fired, but rather the employment relationship is effectively ended by the employer's actions. If you're an employee who feels like your employer has changed the terms of your employment contract, without your consent, you may be experiencing constructive dismissal. So, how do you prove constructive dismissal in Ontario? There are 4 key elements that must be established in order to prove constructive dismissal. First, there must be a significant change to the terms and conditions of employment. This change can include a reduction in pay, hours of work, responsibilities, benefits, or any other aspect of the employment relationship that is considered to be an essential term of the employment contract. Second, the change must have been imposed by the employer. This means that the employer made the change unilaterally, without the employee's consent. If the employee voluntarily agreed to the change, it would not be considered a constructive dismissal. Third, the employee must not have consented to the change. This means that the employee did not agree to the change, either explicitly or implicitly. For example, if the employee continues to work after the change is imposed, it may be argued that they have implicitly consented to the change. And finally, the change must have been so substantial that it amounts to a termination of the employment relationship. This means that the change was so significant that it would have been unreasonable for the employee to continue working under the new terms and conditions. It is important to note that the burden of proof lies with the employee, and they must provide evidence that supports their claim of constructive dismissal. This may include emails, letters, or witness statements that show the changes to the terms and conditions of employment and the employer's actions leading up to the change. An employee who has been constructively dismissed has the option of hiring an employment lawyer or taking the matter to court. If you feel like you may have been constructively dismissed, our team at Randy I Law Office is here to help. We offer free legal consultations to potential clients, and our experienced employment lawyers are ready to guide you through the process. Call us or visit our website today.